Thank you for coming to this seminar. This is the third of our series, and our series of seminar is the rule of law and the legal culture in Hong Kong. And we have conducted a survey in 2015 looking at the legal culture of Hong Kong people. And the objective of our study is to ascertain whether Hong Kong people, they do have the legal culture needed for the rule of law in Hong Kong. As legal culture is a very complex concept, as one of the leading scholars in this area, Professor Lawrence Friedman, said in his works, that is a very complex matter. And so we need to have many seminars to cover all the different aspects of the rule of law and the legal culture in Hong Kong. So this is the third one in our series. And the focus of this seminar is about how Hong Kong people, the legal culture of Hong Kong, sees our courts. Now, when we planned our series of seminars, basically, we work according to the schedule of our speakers, that on their availability, on the time that they will be available. We could not foresee that the seminar will be given at this very, very sensitive moment of Hong Kong, that our court is actually facing a big challenge. And so how Hong Kong people sees the court, though we have provided with the questionnaires and the results of our survey to our speakers, I think they will address the issues on the basis of those results. But I don't know whether they will also comment a little bit on the recent incident, but that will be totally up to our speakers. And we have very prominent speakers today, and we have Ms. Winnie Tam, Chairman of the Bar Association, with us, and also Professor Reyes, and he was Judge of the Court of First Instance, and now the Professor of Legal Studies at the University of Hong Kong. Both of them will give their views on the results of our survey, and after their presentations, we'll have a short break, and then we'll have Dr. Simon will be our discussion, and he will comment on the results and also with the presentations of our speakers. And then we'll have a floor discussion. I hope that we'll be able to gain a lot of insights from the presentations of our speakers. So may I give the time to Ms. Winnie Tam first, and we'll hear her views on the results of the survey. Thank you.
All right. First of all, my apologies for having been late this morning. And thank you very much for having me, Professor Tai. Good morning, everyone. I've been asked to speak on the 3 survey questions that the organizers of this symposium believe to be concerned with the confidence of the Hong Kong public in the Hong Kong SAR courts. I believe that I'm expected to speak on these 3 questions because I have 2 more months to go in chairing the Hong Kong Bar Association. How time whizzed past, and I assure you there hasn't been a dull moment at all. And a barrister who has been practicing in Hong Kong continuously since I returned from my legal studies and training in the United Kingdom after leaving Hong Kong U. Yet another perspective I'm able to share is that from the point of view of a part-time judge, this is no easy job for someone trying to run a practice alongside other duties, but something that I would always commend to my fellow colleagues. It enables a practitioner to view it from the point of view from the bench. Another perspective that I can share today from my experience in promoting the legal profession in Hong Kong and the legal services offered to overseas lawyers and entities. One statistical rating that I often use is the World Economic Forum's Global Competitiveness Report, which has consistently rated Hong Kong highly but particularly highly in respect of the item of judicial independence. In the 2015 and 2016 report, Hong Kong SAR is ranked number 7 as an economy in the overall rating, having been in the top 10 since 2012 and 2013, and ranked number 4 across 140 jurisdictions for juridical independence, scoring 6.3, where the best score is 7 in a scoreboard between 1 to 7. The updated figures seems to reflect a little bit of sort of downgrading in terms of ranking. Nevertheless, Hong Kong is still far ahead of any other Asian countries. According to the report itself, the question asked of the persons polled, who are business executives, is, in your country, how independent is the judicial system from influences of the government, individuals, or companies? One can see that this question is similar to the first question for discussion that I have been asked to comment, which is, to what extent do you agree with this statement in adjudicating cases between private citizens? Judges should not consider the background of the litigants. When we consider the Rule of Law Education Project survey results, a very substantial majority of those of the external legal culture, 85.1% of them, and to whom I include business executives, either strongly agree or agree with this statement. This might tally with the 6.3 out of 1 to 7 scoring in the latest World Economic Forum's Global Competitiveness Report. Another insight that might come out of your survey result can be that this agreement is shared across the board among Hong Kong SAR residents. Turning to the internal legal culture, which you say includes government officials in the policy bureaus of the executive authorities, senior officers in law enforcement, etc., etc., and judges and lawyers, those people that the 2014 State Council White Paper on the practice of one country, two systems in the Hong Kong SAR categorizes those concerned with the administration or governance of the Hong Kong SAR, there is an equal substantial majority in agreement. This result can be taken as an indication of a general consensus in the community to subscribe to this belief that judges in the Hong Kong SAR should not, in the adjudication of cases between private citizens, consider the backgrounds of the litigants. The sharing of this belief by those responsible for the administration or governance of Hong Kong, and by those most directly concerned with the adjudication of disputes, namely judges and lawyers, can be further taken as an impliedly imposed expectation of the judges to do so by those more intimately concerned with the administration of justice, such as the legal profession. I also note the discrepancy between the English and Chinese version of the first question, which affects the perceived scope of that question. Whereas the Chinese version speaks simply of the background of the litigating parties, that is using the words 訴訟雙方嘅身份背景 in the adjudication of cases, and can cover cases where one of the litigating parties in the adjudication is the Hong Kong government. The English version is more restricted. It is concerned only with the courts adjudicating cases between private citizens. The English version, in my opinion, is quite important, since there are from time to time civil actions by individuals or companies against the Hong Kong SAR government. These civil actions can be over relatively ordinary matters, such as a breach of a contract or a traffic accident involving a vehicle driven by a government driver. Or they can be of some public significance, where the public expects vindication after serious transgression of their rights, such as the recently lodged High Court action by a man acquitted of drug trafficking, suing the police for damages for malicious prosecution, false imprisonment, and personal injuries arising out of the allegation that the arresting police officers fabricated evidence of possession of dangerous drugs for the purpose of trafficking against them, or against him, or by another man who said that he was wrongfully arrested by the police during the time of the occupation movement. Under the Hong Kong laws on civil procedure, with a few exceptions such as those regarding the nature of relief that can be ordered and those concerning the entry of default judgments, the granting of summary judgments, discovery and execution of judgments, the government's status in civil actions is as much as an ordinary legal person. It may sue or be sued by the Secretary for Justice. The expectation of both the internal legal culture and the external legal culture ought therefore be that the courts of the Hong Kong SAR shall have no or little regard for the background of the litigants before the adjudication of cases within the court's jurisdiction, since its judicial duty is to adjudicate law and its spirit. The judicial oath, as Chief Justice Ma said in 2011, requires judges to look no further than the law as applied to the facts. The starting point and the end position in any case is the law, said the Chief Justice. Having said that, I have one observation to make. In adjudicating cases through the finding of contentious facts, it is often necessary, and sometimes imperative, that the judge has a penetrating understanding of the background of the litigants. The background I refer to may involve family background, upbringing, social class, culture, including corporate culture, if it's a company that is involved, language, and other matters. This is for the purpose of assessing the meaning, implication, and veracity of the evidence received in court. A failure to understand these matters may lead to a misinterpretation of the evidence. Regarding the second question under discussion today, which is, to what extent do you agree with this statement? That is, if the court makes a decision which may add a big burden to public revenue, it is proper for the government not to follow the decision. Those who are concerned with the administration of justice and those who are concerned with the general administration or governance of the Hong Kong SAR express overwhelming disagreement, about 92%, according to the survey. A proposition that imposes an expectation not on the courts, but on the executive authority or the government of the Hong Kong SAR. What does this tell you about the faith of the officers in the governance of Hong Kong? One can say that they believe firmly in the rule of law and two particular corollaries or implications of the rule of law. The first concerns the administration of justice and is encapsulated by the Latin expression fiat justitia ruat caelum, let justice be done though the heavens fall. Simply put, as a Joad's Dictionary of English Law, a court must do its duty without regard to the consequences. And the consequences referred to in an ancient case cited in Joad's Dictionary were political consequences, including the certain consequence of rebellion. The second concerns the obligation on the part of the executive authorities to accept, obey, and implement the judgments of the courts, which are invariably on the law, giving efficacy to the principle underlying the separation and coordination of Hong Kong's system of powers between the institutions distinctly vested with that of lawmaking, that is the legislature, the law adjudicating, the courts, and the law execution, the executive authorities. Lord Bingham of Cornhill expounded in his book on the rule of law, the principle of the rule of law, that ministers and public officers at all levels must exercise the powers conferred on them in good faith, fairly, for the purpose for which the powers were conferred, without exceeding the limits of such powers and not unreasonably, stressing that this is a fundamental point, for it falls to the executive, the government of the day, and its servants to carry laws duly made that bind all to whom they apply into effect. Nothing ordinarily authorizes the executive to act otherwise than in strict accordance with those laws. On the other hand, the external legal culture, meaning the rest of the population, appeared not to be disagreeing overwhelmingly like the internal legal culture. 16.9% of those of the external legal culture polled agree with the statement that it is proper for the government not to follow a judgment of the court if that judgment may add a big burden to the public revenue. Some commentators may see this as alarming, since the percentage is not an insignificant one. But I find this to reflect the reality in Hong Kong, that not all of our residents have a clear and nuanced view of the rule of law, and that not all of our residents have a similar list or a set of priorities. All these are signs reflective of a pluralistic society. What we do wish to engage in is a rational debate on the matter. An adjudication resolves the dispute between an individual and another individual of the government, and the court's order deals with the rights and interests of those involved in the adjudication only. In this, the usual situation, the question of whether the judgment may add a big burden to the public revenue involves not the court's evaluation, but the executive authority's evaluation of how they would act in the light of the law and principles discussed in the judgment. But how real is the perceived excessive burden? An option reasonably open to the executive authorities is, of course, to change the policy or the legislation. That is, the primary function of the executive authorities is to formulate suitable policies and to put them into effect, either by administrative policy or by legislation, is well recognized in ordinary administrative law principles based on the common law and in the basic law, Articles 48, 56, and 62. I recognize that sometimes the adjudication may have more general effect, such as where the instrument interpreted is the basic law of the Hong Kong SAR, and what is at stake is the validity of a legislative or administrative measure affecting many Hong Kong residents, such as their entitlement to publicly funded benefits. Here, the Court of Final Appeal has, in a number of cases concerning the extent of review the courts should perform in relation to a restriction to fundamental rights guaranteed under the basic law, indicated that there are different constitutional roles played by the judiciary on the one hand and the legislative and executive authorities on the other, so that the former recognizes an area of discretion the latter have in the making of policies in the socio-economic context, including the making of choices regarding the allocation of limited public funds. The effect of this recognition on the part of the judiciary is that unless the impugned measure impinges the core value of Hong Kong society or involves possible discrimination on inherently suspect backgrounds such as sex, race, religion, political opinion, or sexual orientation, the court's duty to intervene applies only where the impugned measure is manifestly without reasonable justification. Again, with the approach taken by the courts and assuming reasonably that counsel for the government would make submissions in light of the court's approach, I ask, how real is this statement? I now turn to the third question, which asks, to what extent do you agree with this statement? The government should ensure people in need will have legal representation in trial. Before I deal with the results of the survey, I wish to point out again a discrepancy between the English and the Chinese versions of the questions, since the Chinese version speaks of the obligation of the government to ensure that residents in need would be able to obtain legal aid. 政府有責任確保有需要嘅市民能夠得到法律援助. Whereas in the English version, it says the government should ensure that people in need will have legal representation in trial. I see that the results between the internal legal culture and the external culture, namely 90.8% under the internal and 93.7% under the external, to be relatively straightforward. The slight difference between these two expressions of overwhelming two expressions may be that the external legal culture, the Hong Kong residents themselves, do have a strong need for publicly funded legal assistance, and they do find that the legal aid schemes administered by the government department responsible, that is the legal aid department, to be essential for upholding a litigant's rights in a trial. In this respect, it may be necessary to point out that the guarantees we do have under the Basic Law and the Hong Kong Bill of Rights are not coextensive with the obligation asserted in this statement. Article 35 of the Basic Law guarantees only the Hong Kong residents' choice of having legal representation to defend their rights on a timely basis. Articles 10 and 11 of the Hong Kong Bill of Rights emphasize the right to legal representation in the determination of a criminal charge where the interests of justice so require. Though the jurisprudence of Article 10 does suggest that in certain circumstances the entitlement of a fair hearing by a competent, independent and impartial tribunal established by law in the determination of a person's rights and obligations in a suit at law may implicate the provision of affordable or free legal representation to him or her. In this connection, I wish to stress that the availability of affordable or free legal representation through public funding is to uphold the litigants' rights and interests in view of the often complex legal proceedings, both in substance and procedure, and to ensure that all relevant issues of fact and law can be articulated before the court by reference to the relevant evidence and authorities, rather than to serve the monetary interests of the lawyers. The Rule of Law and Legal Culture in Hong Kong survey is one of many surveys that we come across that seek to measure Hong Kong's qualities as an economy and society. Each of them follows its own methodology. We can compare methodologies between surveys to enhance the sensitivity and reliability of the one we are concerned with. One such survey that the Hong Kong Bar Association has referred to has been the World Justice Project's Rule of Law Index, which is compiled on the basis of answers provided by 300 local experts of a set of 5 questionnaires developed out of a published conceptual framework with the following themes: constraints on government powers, absence of corruption, open government, fundamental rights, order and security, regulatory enforcement, civil justice, and criminal justice. In 2015 to 2016, of the 113 jurisdictions in this index, the Hong Kong SAR has a global ranking of 16 at a score of 0.7 below the following countries: Denmark, number 1, Germany, number 6, New Zealand, number 8, Singapore, number 9, United Kingdom, number 10, and Japan, number 15. And if one looks at the radar regarding Hong Kong SAR, it appears that our jurisdiction is very strong in the absence of corruption and criminal justice, strong in order and security, regulatory environment, and civil justice, but the matters that probably lead to the SAR not coming within the global top 10 are constraints on government power, open government, and fundamental rights, with lower scores on issues like non-governmental checks, lawful transition of power, freedom of expression, and freedom of association. This survey may provide food for thought for all of us here, and we can discuss that with Mr. Simon Ng as discussant at the later stage of today's proceedings. Thank you very much.
Thank you. Thank you, Winnie. May I now invite Professor Rios to share his views and observations.
Thank you very much. Professor Tai, Winnie Tam, Chairperson of the Bar, Mr. Simon Ng, ladies and gentlemen. There is a mismatch between the question that forms the title of today's seminar, do Hong Kong people trust our courts? A statement or a question that requires a description. Yes, Hong Kong people trust the courts. No, Hong Kong people do not trust the courts. There's a mismatch between that and the 3 questions that form the substance of today's seminar. The 3 questions are all prescriptive questions. They say what the court should do. It should not take into account people's background. It says, third question, what the government should do. It should provide legal aid as much as possible to those in need. And the second question, it says that the court should act in a particular way, even though it may have radical consequences to the public revenue. So the 3 questions all deal with prescription and do not really go towards answering the descriptive question. I take it that my job then is to try to answer the descriptive question that forms the basis of today's seminar. Since it's rather difficult to draw a descriptive statement from prescriptions, I've decided that to approach this, I should borrow from the philosopher Hobbes, Thomas Hobbes. I should look deep into myself and see whether or not, as a result of these prescriptions, and we see how people have voted on these prescriptions, the Hong Kong court is doing what people expect. When I was a judge, for instance, did I have regard to the backgrounds of private litigants? When I was a judge, did I have regard to the consequences to the public purse? Legal aid, well, that one is a prescription for government, so I'll say less about that. Well, perhaps I'll say one thing. Obviously, one should try to provide as much as possible legal aid to those in need. But let me focus on the two questions. Well, when I was a judge, I think that I tried as much as I could to decide matters without regard to the background of private litigants. I think that as much as possible, I tried to decide matters without regard to the consequences to the public purse. And I think, from what I know of my fellow judges, from conversations with them, I think they did the same thing. So my conclusion and my suggestion would be there is a match between what Hong Kong people expect of the courts and, at least looking deep into myself, what I believe the judges are doing. I'd therefore like to address myself to the question of how can the courts maintain their credibility? I gave an inaugural lecture where I dealt with 6 challenges to the judiciary. And I'd like to return to that this morning by simply dealing with 3 points. How to maintain credibility in the future. So I too will resort to prescription in order to maintain what I believe to be the proper description of the current state of affairs, that there is trust amongst Hong Kong people and the judiciary. How can one maintain that credibility? How can the court maintain that credibility? My first observation is that, going back to my inaugural lecture on challenges to the Hong Kong judiciary, my first observation is there is a shortage of Hong Kong judges. And somehow or the other, we have to address that shortage of Hong Kong judges. If the court is going to respond to the needs of Hong Kong people in the future, we've got to have more judges. And we've got to be able to attract judges to the judiciary, attract people to the judiciary. At the moment, it may be difficult to do so. Why? Well, if you have a shortage of judges and more cases, then if you're a judge, it's not going to be a pleasant holiday. It's going to be like a treadmill. You finish one piece of work, you've got another. You've got another judgment to write, and then another judgment to write. And every time you finish one piece of work, more files sprout up. It's very much like Sisyphus trying to roll a rock up the hill. The rock always seems to come down, and there seems to be no end. Who's going to go for that sort of life? We've got to find ways, I think, to improve the working conditions of judges. Our High Court, for instance, the building was inaugurated in the 1980s. I think we need something more modern, something to deal with the demands of the 21st century. The assistants, supportive assistants, secretarial assistants available to judges, that's very important. Secretarial technological assistance. The judiciary is trying to do the best it can at the moment. It's trying to make changes. For instance, at least in the High Court, there's been an attempt to provide one secretary per 2 judges. But I think more can be done to improve the working conditions of judges so that with modern courts, modern courtroom, with a lot of support, it will be attractive to come to the judiciary. Another thing that may be necessary, we can have all these attractions to the judicial workplace, but we've got to have applicants, and we've got to have high-quality applicants. It may be that there is no shortage of applicants to the judiciary, but the Chief Justice has made it clear that what he's after is quality applicants. So we've got to attract top people, top lawyers, top barristers. I would include top solicitors. It's going to be difficult to do that because they earn an awful lot of money here in Hong Kong. The legal business is not as good as it used to be, but it's not that bad either. And as a barrister, as a top barrister, as a top solicitor, you probably earn significantly more than a High Court judge. Well, there are various solutions that one can do. One can take the Singapore solution. It's rumored that the Singapore Chief Justice at the time said, "Tell me what the highest paid lawyer in Singapore is earning, and we shall match that." I'm not quite sure that is an appropriate solution here in Hong Kong, much though, if I were a judge, I'd like that. But there are many other concerns here in Hong Kong, and financial resources are scarce, so that the elderly, the poor, the neglected, students will require financial resources. Judges are well paid, it's just that they can earn so much more in practice. I suggest that one way to address it, and the courts, the judiciary is looking into this, might be to relax a little some of the terms by which judges are hired. For instance, once you become a judge, you sign an undertaking that you will never again give advice, directly or indirectly, to members of the public on matters of Hong Kong law. You can never practice again as, say, a barrister or a solicitor in Hong Kong law. So that becoming a judge is a one-way street. If you find out that you don't like it, or if you retire at a relatively young age, let's say the retirement age at the moment is 65, and still want to do things in relation to Hong Kong law, it's difficult to do so. Now, many common law jurisdictions have had a similar rule, but that's been relaxed. For instance, in Australia, if you're a federal court judge, when you retire, you can still give advice, legal advice. You can't appear in court to argue a case, but you can give legal advice. Nothing prevents you, if you've been a federal court judge, to acting as counsel, as a lawyer, in state-level matters, in state-level courts. Now, Hong Kong is a SAR, Special Administrative Region. We're not a federal system like Australia, but some sort of relaxation of this rule may be appropriate. Another possibility. At the moment, as I've said, the retirement age is 65. Well, there is a very generous pension, but one would also like to do some work at 65. It is said nowadays, and I hope it's true, that 65 is today's 40 years old. I hope it's true. I'm not quite there yet, but I am approaching it in another decade or so. So I hope that that's true. You still want to do productive things. And why not do things in the area in which you're specialized, particularly Hong Kong law? So I would suggest that one way to do it, rather than appoint retired judges constantly as deputy High Court judges to sit 3 months in a year after they retire, I suggest one way to do it would be to raise the retirement age to 70, as in the UK, possibly later, but maybe you want to give others, the young, an opportunity. So some sort of balance there to make it, to allow judges to continue to contribute as judges, as full High Court judges to the community. So I would suggest addressing this problem of getting more judges requires at least two things. One, improving conditions, improving working conditions. Second, relaxing the rules a little bit so that more barristers, more solicitors at the top end feel, yes, I'd like to do it. I'm earning a lot, but I'd like to give back to Hong Kong, and so I will join the judiciary for that reason. The second point I'd like to make, what is the reality today? The reality today is that there are many, many cases in different areas of the law. You cannot expect, as a judge, to have picked up the expertise in these various specialized areas of the law, either when you're a student at law or when you're in practice. What is needed is constantly evolving in time as our society becomes more and more global, more and more digital. And so capacity building is quite important. Our judges have to be equipped to deal with the problems of the 21st century and beyond. I would suggest it's very important, therefore, to have judicial studies, to promote judicial studies. We have such a program here in Hong Kong, the Judicial Studies Program, run under the Center for Comparative and Public Law. The judiciary is currently reforming its Judicial Studies Board. It's creating a judicial college, but it's taking time. And this is not an optional extra. This is something that needs to be done now so that our judges can cope with the demands of the future, with the demands indeed of today. We know the latest techniques, the latest law, the latest thinking on matters such as family law, or matters such as criminal law, and so forth. Things that affect the day-to-day lives of people. Judges cannot be learning their law or experimenting with the law at the cost of litigants. Judges need training, capacity building, sharing with other judges, not just here in Hong Kong, but elsewhere, about how to deal with problems that are special, are not necessarily unique, that are common to different parts of the Asia-Pacific region. So my second prescription would be capacity building. However expert judges are when they become judges, you need constant capacity building in order to meet the demands of today and the demands of the future. The third, one can look beyond further to the future, assuming that we're able to overcome this problem of a shortage of judges, assuming that we are able to put in place a proper mode of judicial capacity building, then we can look to ways to improve the way that our judiciary renders services to the community, in particular to ordinary litigants who encounter the judiciary or the courts in their everyday lives. I'm not talking here about high-flown judicial reviews, the grand theories of political of politics, constitution, etc. I'm talking here about day-to-day matters of family law, day-to-day matters of criminal law, day-to-day matters of commercial law. In terms of day-to-day matters of family law, since stepping down from the judiciary, I've had a chance to look a little bit more closely into the family courts. They are crowded. There are a lot of litigants. There are probably not enough judges to deal with the cases, and cases take a long time, and cases can become very expensive. What we need to do, and again, reforms are working their way, what we need to do is to change the outlook in family law, rather than an antagonistic one spouse against the other spouse, to try to make it a more cooperative effort, to try to promote alternative modes of dispute resolution, to bring it out of an adversarial viewpoint, perspective, into something where both spouses like it or not, have to cooperate with each other. One of the outcomes of Hong Kong people trusting the judiciary is that the Hong Kong people tend to come to the judiciary for just about every question in the world. As Winnie Tam has said, judges are there primarily to decide the law. But you wouldn't think it. When you go to the family court, you have people saying, I want to send my child to this school, and the other spouse saying, no, I want to send my child to this school. And by the way, I'd like an urgent application so that the court will order this, because if I don't register for this school within this particular week, my child will lose all chance of getting into the queue to get into that school. So I'd like an urgent injunction or order for specific performance. Now, what is the judge to do? What is the family court judge to do? It's not really a matter of law. But people trust the court so much that rather than talk to each other, they believe the court can do wonders and solve everything. So they go to the court and say, I want something. Well, what's the judge going to do? The judge really should be saying, this is not a matter that you should involve the court in. You go ahead. I know you hate each other, but you've got to talk to each other. And in the interests of the child, not in the interests of war by any other means between the spouses, you've got to come to a sensible, rational, reasonable decision. And very often statistics show, empirical studies show, if you do that, then they will come together. If they can't, well, there are mediators, there are various social workers that help bring some sort of grudging conciliation, reconciliation on day-to-day matters. Don't always go to court. The Chief Justice has many times in his opening of the legal year speech stressed that the courts are not there to answer just about every question that you have. So whenever you have a dispute, well, trust the court, just go to the courts. That's going to clog the courts, drive out the litigants that are really in need unnecessarily. That's going to use what are now scarce judicial resources. So some perspective is necessary, and I think it's necessary to address this, especially in family law. In my inaugural lecture, I said a few words about criminal law reform. Now, I'm not particularly known to be a criminal lawyer. When I was in practice at the bar, when I was a judge, I think I was more known for civil and commercial law. So I'm not going to say much here, but I endorse what Mr. Justice Stock has said repeatedly when he was in the Court of Appeal and repeatedly now, that it is unsustainable at the moment if we keep on with our criminal justice system in the way it is. We're going to have trials that take too long, people hanging about possibly in jail, waiting for a decision one way or the other too long. Something's got to be done. What exactly has to be done needs to be discussed, by all means. Needs to be debated, by all means. That will take time, fine. But the time to start doing that is now. The third one is an idea floated by Sir Richard Field, who's currently sitting as a Deputy High Court Judge, at a recent lunchtime meeting of the Hong Kong Maritime Law Association. He has noted that there has been a rise in international commercial courts around the world. In the near future, for instance, there will be one in Rotterdam, in the Netherlands. We know about the court, the English Commercial Court. We know about the Dubai International Financial Center courts. We know about the court of which I'm a judge, the Singapore International Commercial Court. Qatar is apparently getting into the act. Abu Dhabi is getting into the act. And rumors are that Kazakhstan is going into the act, also thinking of forming an international commercial court. Well, Hong Kong might consider this, especially if it is able to attract quality people to the judiciary. Why? Well, Sir Richard Field points out that an international commercial court, such as effectively the UK Commercial Court, brings in a lot of revenue, brings in a lot of invisible revenue to the UK. Hong Kong thrives on this financial inflow into Hong Kong, and therefore that is one way that the judiciary can contribute in the future to the Hong Kong economy. Those are just three ideas in terms of the third point that I want to make. that one should be looking into the future in order to maintain and leverage upon the credibility of the judiciary. I would just like to say one more thing about the second question, the prescription. That says you should not have regard as a judge to the financial consequences of a particular measure. If that is the law, then to quote Winnie Tam, the Latin maxim, let it be. Let the law be. Let the law be done, even if the heavens should tremble, even if the heavens should be angry. That's fine. But one of the theories pointed out by Professor Yapo Jen here in this faculty is that there is also room for judicial dialogue, what he calls constitutional dialogue. In other words, consider the Singapore example. Singapore court might hold in a particular way, contrary to the government's viewpoint. When I was in a seminar in Singapore at Singapore Management University comparing judicial review in both countries, in Singapore and in Hong Kong, in both jurisdictions, it was pointed out that very often, if the government didn't like the decision of the Singapore court, it would enact legislation almost immediately after to counteract, to reverse the effect of the decision of the Singapore court. And what ensues is a dialogue between the court, what is required in order to conform with the law, and the government trying to do what is necessary to conform with the law and pursue its own policy. This constitutional dialogue goes around all the time. And that is one of the things that Professor Yapo Jen is exploring in a series of books, looking at different jurisdictions, different types of jurisdictions, to see how this constitutional dialogue is carried out. I would just like to stress, therefore, that the question is only one half of the matter. Yes, fiat lex, ruat caelo. Let the law be, even though the heavens should tremble. But that's not the end of the story. It may be that legislation comes to reverse the decision of the courts, but what that legislation or what the bill for that legislation does is prompt a dialogue, a debate in which society can engage and through that way improve the law. Thank you very much.
Thank you. Thank you, Professor Reyes. We are a bit ahead of our schedule, so I think we'll just keep to the arrangements, and we'll have a break of 15 minutes, and then we'll come back. We have Mr. Simon making his comments, and then we'll have a floor discussion of the issues raised, very interesting issues raised by the two speakers. Thank you.
Couldn't agree more with the things you said.